Hey everyone, and welcome. If you're just stepping into an introductory business law course, you're going to encounter a ton of very specific, highly precise terminology. Our goal in this explainer is to completely demystify the core components of a legal contract. We're not just going to read textbook definitions at you today. Instead, we're taking a ground-up, building block approach so you can truly understand exactly how a contract is formed.
Here is our roadmap for this explainer. First, we'll establish the business legal environment. Then, break down the anatomy of agreements. Look at conditions for enforceability. Explore types of contracts, and finally, untangle void and illegal agreements. Let's get right into it.
Starting off with Section 1, Business Legal Environments. To kick things off, let's ask a foundational question. If I promise to grab lunch with you and I totally flake, you can't exactly sue me for breach of contract, right? Well, why not? It all boils down to the legal environment. You see, business law strictly governs commercial transactions and obligations. It's an entirely distinct arena from, say, criminal or family law. It draws this very hard boundary separating your personal manners and casual everyday promises on one side from legally enforceable business duties on the other.
And the Contract Act of 1872 actually gives us a beautifully concise definition to work with here. It says a contract is a binding agreement between two or more persons that is enforceable by law. For your business law foundations, the absolute most crucial takeaway is that not all agreements are contracts. A contract is basically an agreement that is graduated. It's leveled up and acquired the specific qualification of being enforceable by a court. And for businesses, that graduation means safety. It literally means your money and your assets are legally protected.
All right, moving right along to Section 2, the anatomy of agreements.
So you might be wondering, how do we actually build an agreement that can eventually graduate to become a full-blown contract? Think of it like a legal equation. Step 1 is the proposal. For example, me saying, hey, I'll sell you these goods. Step 2 is acceptance, where the client simply says yes. Now, this perfect union of a proposal and an acceptance equals Step 3, a promise. But hold on, we actually still aren't at an agreement yet?
To actually reach an agreement, we need this one critical piece: consideration. In simple terms, consideration is just the exchange of value. I give you a product, you give me cash. It's the necessary glue. Legally speaking, it's defined as an act, abstinence, or promise done specifically at the desire of the promiser. And that last part, that is a massive caveat. If a completely random third party desires the act, it doesn't count. Without this specific exchange of value meeting that exact condition, a promise simply cannot bridge the gap to become a legal agreement.
Okay, let's summarize our legal equation so far. Promise plus consideration equals an agreement. It's that simple. Every single promise and every set of promises that form the consideration for each other mathematically equals an agreement. If you have an accepted proposal, which remember is a promise, and there's valid consideration backing it up, you've successfully built yourself an agreement.
Which brings us to Section 3, conditions for enforceability. How an agreement becomes a true contract. Now, let's throw a rhetorical roadblock in here. We have an agreement, sure, but is it a contract? Well, not quite. Working from the foundation up, a simple agreement really has to clear a series of specific hurdles. It essentially has to prove it's agreeable by law, to finally reach the top of the pyramid and be recognized as a fully fledged contract.
Let's break down the 5 absolutely strict conditions required for enforceability. To be a real contract, an agreement needs 1. Competent parties, meaning they have to be legally capable of entering a contract. 2. Free consent. Absolutely no one is being forced, coerced, or tricked. 3. Lawful consideration. The actual value being exchanged cannot be illegal. 4. Lawful object. The underlying purpose of the contract has to be legal. And 5. The agreement must not be expressly declared void by law. And here is the kicker. If you are missing even a single one of these variables, the outcome is void. The whole agreement fails the test.
All right, Section 4, Types of Contracts. Now that we know the exact equation of how a contract is mathematically formed, how do these binding obligations actually show up in the real world? Well, broadly speaking, we have express versus implied contracts. Express contracts use expressed words. Implied contracts, on the other hand, are formed purely by actions, no words needed. Imagine a shoe shiner who just walks up and starts polishing your shoes. You stay completely silent, but you knowingly permit it, understanding he expects to be paid. While your silence and your action just fulfilled the legal equation of offer and acceptance. The law treats that scenario as a completely binding implied contract. Crazy, right?
Now, when we look specifically at express contracts, they actually break down into 2 everyday subsets:
written contracts and oral contracts. The crucial point you need to remember here is that both are legally binding expressions of words. Whether you draft a massive 50-page vendor document or you just verbally agree to buy a supplier's inventory for 3 lakhs over handshake, both completely fulfill the requirement for an express contract. They just utilize different mediums.
Finally, let's look at Section 5, void and illegal agreements.
We've spent this entire explainer building the contract up piece by piece. But what happens when the legal equation fundamentally fails? Let's highlight a vital chronological difference in business law: the distinction between a void agreement and a void contract. A void agreement is basically dead on arrival. It was void from its very birth and was absolutely never in a position to be enforceable by law. A void contract, however, that was valid once upon a time. It started out as a fully enforceable contract, but due to some subsequent unforeseen event, it ceased to be enforceable. It loses its contract status later in its life.
Now consider the concept of an illegal agreement. This is an agreement whose object or consideration is strictly unlawful. And because it's unlawful, it is inherently a void agreement. But here's the really critical distinction you need to make. While all illegal agreements are void, not all void agreements are illegal. Illegality is just one specific ground for being void. For example, if we make an agreement for me to write 100 pages in 5 minutes, an impossible task, well, that agreement is immediately void, but it certainly isn't illegal.
To wrap up our explainer today, I want to leave you with a bit of a paradox to test your understanding of everything we've just built. If legality is strictly required for a contract to even exist, remember our 5 conditions for enforceability. Can an illegal contract ever truly exist? What do you think? Well, the answer is no. It creates a paradoxical self-contradiction. An agreement enforceable by law cannot, by its very definition, be illegal. Therefore, illegal agreement is the exact correct legal term, but there is literally no such thing as an illegal contract. I really hope this step-by-step breakdown is giving you a rock-solid foundation as you navigate your introductory business law course.